So we're going to move on with our Ohio Division of Securities section updates, which is a perennial feature here on the Securities Conference agenda. So I will turn it over to Anna Sitzman and John Chris. Thank you.
Good afternoon, everybody. Hopefully you're all enjoying your lunch. And if you are still chewing and unwrapping things, don't worry about it. We're very happy that the lunch came and hopefully you're all enjoying it. My name is John Chris. I am the compliance director here at the Ohio Division of Securities. And I'm going to be giving the section update for the newly created compliance section. Jake's presentation could not have come at a better time, because in fact, I have enlisted the help of a language model in my presentation. So I have, Google has a language model called Google Notebook LM. And what you can do is you can put in a media source of articles, presentation, YouTube videos, whatever, and it will present the information to you in whatever, in a number of formats. One of the ways that it will do that is it will create a podcast and present the information as if there's two AIs talking back and forth about the source you put in. So what I did was I recorded myself doing this presentation just in practice, and I transcribed it, so there was a text of it, and I put it into Google language model and created a podcast. And this is a win-win for me, because one, if the information's wrong, it's a new technology. And second, if you think it's boring, I can always just blame the robots. But so we're gonna get started. So I cut it up in different segments. The slides are mine, the content is mine, but it's gonna be presented in kind of a different way. So to get started, let's see if this works.
Everybody, welcome back. Ready for another deep dive. Today we're taking a look at the Ohio Securities Act. And wow, have you given us a lot of work? Historical documents, a message from Commissioner Safe herself.
You can have some glimpses into the future of the division. This is exciting stuff.
It really is. Okay, so where do we even start? Past, present, future. You know what? I think this quote you found from way back in 1929. This is the perfect place to begin. Talk about setting the stage.
Yeah, it's here.
Okay, so it says, and I quote, "A law which will not only throw the crooks for a loss, but will at the same time cut away the entangling meshes of red tape." They weren't messing around.
I love that. And, you know, almost 100 years later, that still rings so true.
Right.
That's the core challenge of securities regulation. How do you protect investors without putting businesses in a straitjacket? It's a tough guy.
It really is. And it's amazing to me, thinking about that quote, that Ohio was already ahead of the game back then. I mean, they launched this that even before the 1929 Act, before the SEC even existed.
Exactly. It really shows you how seriously they were taking investor protection right from the start.
Absolutely. Speaking of that commitment to investor protection, you included this message from Commissioner Safe.
Oh yeah, from this year's conference.
Right, celebrating the 50th anniversary.
50 years, that's incredible.
I know, that's a huge milestone. But
Okay, so that was all AI, and you see it makes it a little bit more fun. So, again, my name is John Chris. If you interact with our compliance section, you're going to interact with one of these folks. This does not include our field examiners, but Paul, who chief legal at Coinbase, uses this comparison. I'm going to steal it. He says that he is like the Phil Jackson to Scottie Pippen and Michael Jordan and all of the All-Stars. And I feel the exact same way. The group of folks that we have in your compliance section of the Ohio Division of Securities are talented, smart, dedicated, really wonderful people. And if I can say, just above all, they're very kind people, which is wonderful. You know, I can't turn on a YouTube video without hearing how scared I should be of my neighbors and my fellow citizens. So to go to work every day with people who I like, who I respect, who I enjoy, it's a real gift. But just going over a couple of Jeff Coleman, Stephanie Khalid, Glenn Scobo, Cynthia Sir, Pam Edgerton Saunders, and then if you're on the product side, Kelly Kaufman, Inez Jackson, Ryan Rogers, Tanika Brown, and Chris. And our field examiners, who I should have included here and I didn't, sorry guys. 3 of which, 60% of which are in this room. Don Taylor, Dave Melito, Kevin Armstrong, Rich Carpenter, and Will Patinas. Okay, so this year, we went over and did a big change. We had our longtime registration chief counsel retire, Mark Hireman, who many of you worked with, and our longtime licensing chief moved on to FINRA. And to explain, I'm gonna again enlist the help of AI.
Puzzle here, right?
Restructure.
Right. Big shakeup. What's the deal with that?
Okay, so remember how the division used to have those three main sections?
Let's see. Enforcement, licensing, and what was the other one?
Corporation finance.
Right, corporation finance.
So you can kind of think about it like this, three Ps, problems, people, and products.
Okay. Break it down for me.
So enforcement, they're the ones investigating potential violations. Licensing handles, well, licensing for brokers, dealers, investment advisors, all that.
Keeping everyone on their toes.
Exactly. And then corporation finance, or CorpFin, as it's affectionately known, they focused on registering securities.
Right, right. So what changed?
So they took licensing and corporation finance and they merged them,
Really? Into one mega department?
pretty much. They call it compliance now. So now you have enforcement and compliance, the two branches.
Interesting. Streamlined for sure. But I have to ask, does reorganizing a couple of departments actually make things better? I mean, is it really that simple?
That's the $1 million question, isn't it? And time will tell, it's still early days. But the thinking is that by bringing licensing and CorpFin together, they can create this more holistic approach, you know, more proactive. Like instead of these two departments operating in their own little silos, they can share information more easily, collaborate more closely.
So that's your problem, not mine.
Exactly, and the hope is that ultimately it will lead to better, more effective regulation.
And hopefully fewer headaches for everyone involved.
Right. Because let's be honest, navigating the world with security regulation can be, well, let's just say it's not always the most user-friendly experience.
Definitely not known for being a walk in the park.
Exactly.
I just want to point out, it would have been hysterical from my perspective only if I had just done the entire presentation, hitting a button and letting AI just do it. But I do want to talk for a moment about why we're doing this big restructuring. You know, the division has two goals, which we share with a number of securities regulators. We want to facilitate capital formation, and we want to protect our investors, especially the most vulnerable. And on the compliance side, particularly the product registration side, where I've spent my entire career at the division, we have largely done this by being reactive, which is to say, our view of the Ohio capital markets is informed by the filings that come in that we will then review and issue comments on. It's also informed by the questions that we take, by the letters that we receive. And, you know, in other words, we're very reactive. And of course, on the examination side, that's more proactive, but we would like to do more. And what we have come up with is that this will largely come from the way that we use and collect data to form a more holistic view of the capital markets in Ohio. And you know, Case is my alma mater. And some of the first principles that I learned here that we're going back to are to be curious and to break down complicated issues into smaller parts and be able to explain them. And so basically, I want to know everything about the Ohio capital markets. I want to know who's investing. I want to know what they're investing in. I want to know how they're investing. I want to know what salespeople are doing. I want to know what advertisements they're using. I want to know what are the barriers for their investments, and everything else. And so this comes from being able to form a holistic view that's not just based on the filings coming in, but based on what's going on out in the capital markets. So basically, you know, two questions. What things do we do that we don't need to do anymore? And second, what things do we need to do that we're not doing? And to provide an example of the second, a later slide we'll talk about some of the pathways that the registration of the investing public uses. But I'm going to give you a couple of examples of where I've seen this done well in different states and different regulators. The first is with Florida. Florida has recently enacted some statutory changes that eliminate one pathway to exemption that wasn't being used, their intrastate crowdfunding act, and they expanded the second one that is being used, which is their limited offering exemption. So we have a limited offering exemption. Ours is limited, if you sell to 10 or fewer Ohio investors in a calendar year, there's no filing, no fee required. But because there's no fee coming, there's no filing coming, we have no data on how much it's being used. So we can't support at this time, getting away with this, getting rid of this one and expanding this one because we don't have the data yet. And that's what we want to work on. Second thing I want to highlight is this wonderful data that we got from the FINRA. FINRA has it's awesome. It's FINRA Investor Education Foundation, and this is public data. But what they do not have on their website is actually state level data. So if you go on the website, you can they'll have all these sort of interesting questions that they answer, that they address about how investors across the country are behaving. And but we didn't know at the time is that they also collect state level data, and we requested and they were gracious enough to present it to us. So for example, we learned that, and this is state level data, 60% of Ohioans are not confident that they could come up with $2,000 if an unexpected need arose in the next month. 60%. We also learned that Ohioans invest in stocks, bonds, and other securities outside of their retirement account at a lower rate than both the nation and the region. And that region is the Midwest region. But they regularly contribute to their retirement account at a slightly higher rate. We also learned that Ohioans, compared to the nation and the region, struggle with some basic financial knowledge metrics. So, for example, questions like, suppose you had $100 in a savings account that earns 2% per year. After 5 years, how much will you have in that savings account? Ohioans were unable to answer that question at the same rates as their and regional peers. Similar questions with the behavior of bond prices and interest rates. Ohio investors answered at 21% as compared to 25 and 23 respectively. So this is just an example of some really interesting data that should inform the way that we approach our capital markets. I mean, for example, we spend a good amount of time on investor outreach. This sort of information would color how we approach our investors. Instead of just waiting for a filing to come in and review that, now we have a more holistic picture of the Ohio capital markets. Diving into the weeds for just a few minutes, I did want to touch on the stats that we received, of the filings that we received. This is measured on a fiscal basis, and in that time period, we do see an overall increase. One subset that we see a minor decrease on was state registered investment advisors. And there are about 650 that are domiciled here in Ohio, and we are the primary regulator for those, and we'll be the ones conducting examinations for them. It's a population that has been decreasing the last few years, down from 865, which is what it was right around COVID. And the biggest growth that we've seen, which might not surprise many in this room, is with the SEC investment advisors that notice file in our state. That population has been growing for several. Quick reminder, I will not read every single word of it, but I do want to send out a reminder for renewals. And that lets you know that from December 27th to January 1st, CRD and IARD systems will be unavailable, and but they will be back by January 2nd. But please do take notes of these deadlines because they are important. Okay, so staying for a moment on our sales person and IARD application reviews, we review over 50,000 applications a year. And the most common deficiencies listed here having to do with incomplete, outdated disclosures, fingerprinting, and competency exams. And I mentioned our wonderful examiners. In preparation for this, I asked them for their top 5 most commonly noted deficiencies. And I actually presented this to Glenn Scoville, who is in charge of our examination program. He said, it sounds a little negative. You should rename it opportunities for improvement. So, these are your opportunities for improvement. And I will note, let me see, that Ohio has this wonderful resource called the Ohio Investment Advisor Handbook. And and there are tips for each one of these deficiencies in the handbook, so I'm gonna highlight these, but I'm not gonna read them to you, but I do wanna point out. That if you need some tips and advice on this, the handbook is an excellent resource for this. Okay, so our top opportunity for improvement is with compliance manual. This might not surprise you if you've been following regulatory developments in Ohio, because we had some substantial rule changes in 2021. And as a result of the 5-year rule review, and a lot of these changes affected our licensees. Some of it was simple things like keeping up with technology. The SEC panel mentioned record keeping. So things like incorporating electronic and digital communications in your records. But we do continue to see outdated or incomplete compliance manual as it needs to be updated to reflect those changes. And language and tips from the handbook here.
Love it.
Oh. Forgot. Okay, so the second one, because this slide can be pretty dry, I'm gonna enlist the help from our AI language manual to discuss the second opportunity for improvement, which is with Form ADV.
Love it. Okay, we tackled the compliance manual. Now on to another one. It can sometimes feel like climbing Mount Everest. Form ADV.
Ah, yes. Form ADV, the document that never ends.
Seriously, it's long and detailed, and if it's not accurate and consistent, it can really make or break you. Not just with clients, but with regulators too.
100%, and that's actually where we see a lot of advisors serving up consistency between part 1 and part 2.
Okay, so for those who need a refresher, part 1 is all about the business, and part 2 is more about the client experience.
You got it. Part 2 is where you lay it all out for your clients, all this key disclosure.
Transparency is key.
Exactly. But here's the thing, in part 2, how you deal with things like conflicts of interest, and that doesn't match up with what you've got in part 1 about how your business actually operates.
Red flag city.
Major red flag. It's like saying one thing and doing another. Not exactly building trust.
Not at all. And speaking of trust, transparency is key, which is why we also look super closely at Form U4.
Ah, Form U4, another fun one.
Right. For our listeners who might be thinking, hold up, what's Form U4? It's basically where advisors spill the tea on any disciplinary history, client complaints, liens, you name it.
Full transparency is the name of the game.
Honesty, always the best policy. So to recap, we've covered keeping that compliance manual updated and making sure your Form ADV and U4 are accurate and consistent.
So
You guys feel like the robots are yelling at you? I don't know how to adjust that. I don't know why I asked the question. Okay, so tips from the compliance manual on your Form ADV. I know that's a long form. But we do expect it to be consistent. And I think because Form ADV and Form IARD, Form ADV is in the IARD system along with Form U4. I think we could probably include Form U4 issues with this category here. And I'm looking at the examiners to see if they're not doing or but okay, so number 3, opportunity for improvement, financial statements. And the tip from the handbook. Financial statements are required quarterly, which includes balance sheet and income statements. So these comments would reflect outdated or non-updated financial statements. And again, the tips from the handbook. Issues with fees. We continue to see issues with fees being calculated correctly. So a few situations we might see with our fees. Situations where an IA will calculate the fee and tell the custodian what to take out. Sometimes that's just miscalculated. Sometimes the advisory fee charge does not match within the client agreement. And situations with paying unearned fees. So for example, if there's language in the contract that says something like, should the clients wish to cancel within the first couple months, then the fees for the remainder of the 12 months will be paid. Ohio has a prohibition against advisors retaining unearned fees, so that would be a deficiency. And lack of suitability. Again, the rule changes in 2021 mandated that suitability be maintained and updated every 3 years or when a material life event occurs. So job change, spousal situation, in those situations, suitability should be updated. And it's our expectation that advisors are conducting suitability anytime they're making a recommendation, but also just when you're meeting with the client to make sure that the information is up to date. Other sources of opportunities for improvement, and I'll just point this resource out to you. I don't want to go too far into the weeds on this. But NASA released a report, 2023 Investment Advisor Coordinated Exams, and that they identified deficiencies. And I will just point out that what they are seeing largely matches what we're seeing. They did not, obviously not every state had administrative code updates in 2021. So it changes the data a little bit, but what we're seeing in Ohio matches what other states are seeing across the country. Ohio is, and it has been and remains in the top 7 in terms of branches. This number dipped around COVID and it seems to be back up to where it was in pre-COVID levels. One quick update I will give here, just because I've got the room. We get questions on this. FINRA now allows a private residence, a non-branch location from which an associated person can engage in supervisory functions. We will consider whether or not to make corresponding changes in the next year with our 5-year rule review. So if there are questions about the RSL rule, we're happy to discuss those with you, but I did want to mention it because it is a common question that we receive. Moving on to our product registrations and what we're seeing. These numbers, the gray numbers, are from the SEC, the SEC Small Business Advocacy Office. And we are seeing the bulk, and this is from 2023, the majority of the money being raised via registered offerings is being raised via mutual funds, exchange traded funds, money market funds. Almost $9 trillion annually, as compared to a sliver of that going into initial public offerings. And about 1.1 trillion flowing into other registered funds. So this is non-money market, non-exchange traded funds. And in Ohio, again, this is what we're seeing. This is the graph, and I don't know why I did this, but the x-axis goes from on the left, the most recent to the least recent, so it's going the wrong way. But this is 99% of our filings are mutual fund filings, investment company filings. And so again, what we're seeing in Ohio matches what SEC is reporting nationally. I will just point out that this is not the amount of dollars. We just receive the filings. This is the pure number of filings. So keep that in mind as you're looking at it. On the exemption side, Regulation A, which was touted as a new regulatory pathway, is not, well, Reg A tiers 1 and 2 is not being utilized much anymore. Reg A tier 2s are being utilized much more than Regulation A tier 1s. But in 2023, only $1.5 billion was raised, as opposed to 506C, which raised almost $170 billion. And the queen of the ball, year after year after year, 506B, which raised almost $3 trillion. So as compared to 169 billion for 506C, $3 trillion flowed in via 506B. And so what this suggests to me, this is just my unauthorized opinion. The views I have don't. I don't think I have to do that. And if I do, I'll do it next year. Is that issuers continue to rely on a safe and compliant and known path towards exemption over innovation. So they are looking for ways to make sure that they know that they have the exemption. And so as a result, we're seeing a ton of money being raised via the classic 506B exemption. And again, this is what we're seeing in Ohio. This is again the total number of filings, and we'll break the actual filings down via exemption type on the next slide here. And you can see 3X is our notice filing provision for 506Bs and Cs. Something like 96% of the filings we receive are Form D filings. That it completely dwarfs all other exemption filings. And the number of filings that we receive that actually register in the state, and I started to say, try to register in the state, every single filing that we had that tried to register in the state was ultimately registered that year. But all the exemption filings that we see are 506B, 506C. We do continue to review our Form Ds as they come in, as we're able to. The most common issue that we see with Form Ds is the unlicensed payment of sales commissions and finder's fees. And the way I like to think about this, and I've made this comparison in the past, it reminds me a lot of Van Halen and the story about their brown M&Ms. I don't know if you guys are familiar with the story. But Van Halen used to have a very complicated set with pyrotechnics and flames flying out and harnesses that had to be exactly to their specification. And so they had this very complicated contract. And to ensure that the venues were reading their contracts, they used to put in a provision that said, we want a bowl of brown M&Ms in our waiting room when we get there. And this was reported, widely as Van Halen is such prima donnas that they want someone to waste their time going through and make sure there's brown M&Ms. But in reality, what it was that it was a signal to them that people had read the contract and taken it seriously. And so again, going back to that lesson I learned on 506Bs is that, this is a compliant group. And the folks that are filing Form Ds don't make mistakes. And so if we see a typo in a Form D, it stands out. If we see an unlicensed payment of sales commission, it stands out. And so, when we are focusing our resources and trying to identify which Form Ds to dig in on, some of these items are the brown M&Ms, and we will look at that and say, okay, looks like somebody is not being compliant. A few of our product exemptions, pathways that we don't receive filings for, and these are some of the pathways that we're interested in getting more data on. 030 and 1301-602D are limited offering exemptions to both equity and debt, respectively. And they will exempt, without a filing or a fee, sales of up to 10 Ohio investors in a calendar year, and also 03B, which is private resale, sometimes referred to as 4A and a half. Okay, this past year, the Ohio Division of Securities did something it had not done for over 40 years, which is that we held a fairness hearing. A fairness hearing is an interesting process because it's something that the state can do that meets a requirement at a federal level. So in the case that there were two banks with strong Ohio nexuses that were seeking to merge, and they wanted to rely on Section 3A10 of the Securities Act. But a central component of 3A10 is that you need to get a fairness hearing. You have a hearing where the folks to whom the securities are being offered are able to go and voice their opinion on it. So we held one, and if you want, let me see if I have an AI video actually that's going to explain fairness hearings. But we have a bulletin article that we wrote on it, and the link will go in more detail than I'm going to go in this presentation. And that's the background of it behind the AI video. But I did ask ChatGPT to rewrite this bulletin article in a way that's a little bit more fun. And then I asked an AI video service to make it so that it looks like a woman's reading it. So here we go. Bear with me, because if you think this is dumb, you're in for a little bit more.
Understanding fairness hearings in Ohio. A fun opening. Imagine planning a party and needing your neighbor's approval to ensure everything's fair. This is what Ohio companies do when they want to reorganize or merge. They hold a fairness hearing to get the Division of Securities to evaluate their plans. The process, getting started. To kick things off, a company files a Form 4 with a $100 fee, like paying a cover charge. This form details the proposed changes, laying out the plan's context, regulatory background, and financials. Think of it as sending out an invitation with the menu. After the division reviews it and asks questions, the company sets a date for the hearing. This hearing is crucial because it helps fulfill the requirements of Section 3(a)(10) of the Securities Act, which ensures that the terms of the securities exchange are approved after a fairness hearing where all affected parties can participate. The hearing. Let's hear it. During the hearing, company reps and shareholders share their views, focusing solely on the fairness of the deal. No off-topic debates allowed. A hearing officer oversees this, ensuring everyone sticks to the script. If the officer finds the proposal fair, they recommend approval to the commissioner, who can then officially give the go-ahead. Quick tips. Local connections. Only companies with ties to Ohio can apply, like needing to know your neighbor before inviting them. Timing is key. Don't start the party until you have approval, otherwise you might face penalties. Mind your words, any chatter about the deal counts as pre-party hype, so be careful. If you have questions about the process, the division staff is ready to help, like having a friend for party planning advice.
Obviously on the beach, and I'll send an AI video. Okay, last slide for me, just one update that I do want everyone to be aware of. Which is something that I have not had a lot to do with, but it's something that the division is very proud of, which is recovery within reach. The division did a set of research that found that 35% of financial advisors suspected that they had clients who struggled directly or indirectly with opioid addiction, but that only 9% reported that they knew how to assist those clients. And so Andrea created this amazing resource and did a training called Recovery Within Reach, which has resources, whether addiction is affecting you, your family, your clients, your relatives of your clients. But to put the information and resources back in your hands. And as somebody whose family has been touched by the opioid crisis, it's really wonderful. And because she's too humble, she won't tell you this, but Andrea won a PR Daily Nonprofit Communications Award in New York City at the end of September, and we are very, very proud of her. So if it's helpful to you, please check that out. Please look for the trainings that are excellent. That's all I'll turn it over to Janice.
I don't have any rock concert stories or anything like that, so you can take it down. Yeah. I'm gonna start out with, hopefully we can get the PowerPoint up on the screen. Really, the first slide is just an overview. It's the standard slide that I start out with. And that's just an overview of who we are. So the Office of the Attorney Inspector, which is the enforcement section of the Division of Securities, is a criminal justice agency. And the information that we have is confidential. The information that we obtain, the information that we utilize as part of our investigative process is confidential and shall in no event be available for inspection by the public. So if you're dealing with other law enforcement, and you're dealing with the Sunshine Law, it's 6 months post the file closing or final resolution. For our records, it is in no event. So in perpetuity is how we're looking at that. All right. So I want to start out with the best thing that I think has happened. I've been with the division since 2010, and that is the ability to give money back to investors who have been taken from. And that is the Ohio Investor Recovery Fund. We reported out on that, the inception of that last year. And this went into place in October of 2022, and it allowed for recovery up to 25% of the loss sustained by an Ohio victim, or 25,000, whichever is lesser. It's funded up to 250 million. I'm sorry, 2.5 million. I wish it was 250 million. 2.5 million per fiscal year. And as of September 30th. We've given back over $1.7 million to Ohio investors. That's 111 applications approved. And this calendar year alone, that figure is $472 to 22 applicants. How to apply, you have to be eligible to receive recovery. And I will tell you that we are proactive in identifying who may be eligible. So you have to be identified in a final order issued by the division. That includes administrative orders, criminal convictions, or final civil orders. We are sending out letters at the beginning of every month for all the investors or victims that have been identified, letting them know that they may be eligible for recovery. People can file online, they can file via email, they can file via mail. The second legislative update that we've had relates to referrals for elder exploitation. This is legislation that passed back in 2021. And I want to tell you what the impact is as a boots on the ground perspective for this. This is the legislation that allows licensees to place holds on accounts if they believe that the client account holder is being victimized. And if they do that, they can put that hold on for 15 days, extend it for another 15 days. If they do that, they have to file a referral with our division. And we do look at everything. We look at everything that comes in to determine whether we have jurisdiction. We don't have a minimum dollar amount. So if somebody's being taken for $200, we're going to look at it just like we would if we have, a $40 million fraud. The benefits of reporting to us are our resources that we have. Obviously, we have the ability to investigate. We can issue subpoenas to bank accounts. We can bring people in to have them testify, tell us what they're doing. If it's a caretaker, we can, call them to question about what they're doing as it relates to the financial accounts. And we have a staff of 10 enforcement attorneys, 3 investigators, 2 forensic accountants, and 3 admins. So we have 18 strong in our division. Since the legislation was passed, we've had 170 referrals to our division. And that 69 of those referrals came in this calendar year alone. So let's turn now to some enforcement stats. I'm going to give you some statistics and some cases that we're working on the administrative side, on the civil side, and then on the criminal side. So first of all, administratively, 2024 to date, the division has issued 40 administrative orders. 15 of those are notice orders, so stating the allegations for the administrative violations. 25 of those orders are the final orders, have been final orders. 6 have been by consent. I want to talk a little bit about 3 of those administrative orders because the state of Ohio is very active in NASA multi-state investigations, and NASA is more active than ever in conducting multi-state actions and in being collaborative to look at national actors that may be violating securities laws throughout the U.S. So the first case that settled is the Raymond James case. The multi-state investigation resulted in findings that Raymond James had minimum trading pricing for low trade amounts, and they weren't implementing that through their internal processes. So they had a minimum $75 commission for all trades, but if that was a low equity trade, then that was reduced to somewhere between $0 and $35. Internally, they weren't applying that lower commission amount, and so the end result was that clients were overcharged. The revenue to Raymond James nationwide was $8.25 million. The impact here in Ohio was about 9,700 clients who were overcharged about $302,000. So Raymond James was cooperative. They came to the table, they consented. They actually paid back to all of those aggrieved clients the overcharged amount plus 6% interest for those amounts. So it was a great result by NASA and the multi-state states that coordinated that. The next case is the TradeStation crypto multi-state action. This was an investigation into TradeStation crypto, who were offering digital asset trading accounts with an interest feature, and they were advertising these accounts as passive income. They were using the word investment and how they advertised them. Obviously, the person holding the account didn't have to do anything to earn that interest feature. Trade Station came to the table and consented to an unregistered charge, an unregistered finding. And they agreed to stop, to cease and desist from continuing to offer these accounts in the US until they had sufficiently complied with securities regulation. They also agreed to pay fines of $29,000 to each of the participating states. The last multi-state case is Plutus Financial. This is Abra Boost. Plutus was offering the same type of deal, interest earned on digital assets. It was slightly different. Abra began winding down US retail operations during the course of the investigation, but continued to negotiate through settlement. That case did settle, and they agreed to liquidate and return the accounts to all of the clients who had these types of accounts. In Ohio, that was about 225 investors for a total amount of $116,000. Okay, this year, we have been incredibly busy in enforcement. And before I get into this slide, I want to thank Chad Kohler, because everything on this slide is Chad Kohler's work, not only in presenting the case, but also briefing it on appeal and then arguing it sometimes at a higher level if need be. So we had 3 pending administrative appeals from administrative orders. The first and the last one are connected. Level Partners was a state registered investment advisor firm. Christopher Henneforth was the president and also the investment advisor rep for that firm. The findings after an administrative hearing were that Mr. Henneforth and his firm were engaging in manipulative, fraudulent, and deceptive conduct as an investment advisor. They were selling that Christopher Henneforth had entered into an agreement with a third-party issuer to become an officer and also to receive compensation from them. As part of that agreement, he set up a separate account that he had sole custody and control over. And he reached out to his investment advisor clients, took on through that separate account about $925,000 from his clients. And when we analyzed those accounts, other than about $195,000, which went to the issuer, the remainder went to pay back prior investors and also went into Mr. Henneforth and his partners' own pockets. So it was, I will say, a mini Ponzi scheme that he was running through an account that he had sole custody and control over. Not surprisingly, the commissioner upheld the recommendation by the hearing officer to revoke both of their licensures. It was appealed, both parties appealed in that case, to the Court of Common Pleas, where the judges in those cases upheld the revocation. Mr. Henneforth then appealed to the 5th District Court of Appeals, and that appeal is still pending. And the other case is Ryan Tariani. Mr. Tariani got in trouble with the Ohio Department of Insurance for submitting falsified annuity withdrawal forms. And the ODI revoked his license. He also got in trouble with FINRA for providing false information as part of an investigation. And so he took a lifetime permanent bar from FINRA, lost his insurance license, failed to update his record with us. We took a good business repute action and he also failed to comply. So we asked for records. We asked for him to appear for testimony. We gave several continuances on that to make it easier for him. He discontinued to comply. Discontinued to comply, or continued to not comply, and eventually his license was revoked. He has appealed that action as well. Okay, we have 2 pending civil actions. This is the Safeguard Metals case that's filed out in the U.S. District Court in California. And then we have the Mark Dent case, which is filed here or close to here in Summit County. The CFTC versus Safeguard Metals case is a case where we joined 30 other state securities regulators and the CFTC to file jointly in the District Court in Central California to identify violative conduct by Safeguard Metals. And what, there are some states, and I had a discussion about this last night, there are some states that have dual authority, right, commodities and securities. In Ohio, we do not. In states like California, they do. So we combine with the CFTC, what Safeguard Metals, or what the allegation is that Safeguard Metals was reaching out to investors and advising them to liquidate their securities accounts, retirement accounts, 401ks. In certain instances, they were on recorded phone calls with custodians that we have, where they're providing specific advice about what securities to liquidate and how to transfer those through, in most cases, a self-directed IRA for purchase of metals than through Safeguard Metals. What Safeguard Metals also didn't disclose is that they had a huge markup on the metals. They were not giving them value, and they were not saying that we're taking any type of fees on top. So what happened is that when investors received their first self-directed IRA statement, the value in their accounts was significantly lower than what they had invested. So that is a basis of the fraud for us as a securities regulator, is the providing investment advice without a license, and also fraud related to those activities. There was a consent order that was issued in that case, both on the civil side, and then they agreed to consent in all the states that had joined on that action. It is still pending the matter of restitution to leaders. I won't say a lot about AEM because it's still ongoing, but Mark Dent was a former Copley High School basketball coach turned alleged real estate flipper extraordinaire. He took on millions and millions of dollars from investors, including, including a lot of elderly folks. People lost their life savings. We worked with the AG's office, Chad Kohler, to file a complaint to freeze those accounts. There were assets that were identified that we knew. There were boats and jet skis and houses and bank accounts. So we moved quickly to file to freeze those accounts. There is a receivership set up in that case as well, and they're still pending on the matter of restitution. Okay, let's talk about criminal stuff. The Ohio Securities Act has criminal penalties. $1 is a felony. And you get to a felony of the first degree, which is up to 11 years in prison, at $150,000. So not only do we have criminal authority, that authority was a pretty heavy hammer as it relates to the level of felonies in our cases. This year to date, we've had 11 pending criminal cases. So these are indictments based upon our investigations and our referrals. Those are the counties listed there that we have pending cases in. Those 11 cases relate to 54 victims and over $4.3 million in loss. We had 4 new indictments, and we had 3 cases that either pled and or were sentenced. A restitution was ordered on those cases for over $370,000. $91,000 of that was paid at sentencing as part of mitigation. Okay, I'm going to talk about what we're seeing a lot of, and what we're seeing a lot of is cryptocurrency and internet fraud. So I'm going to start out with this stat from the Internet Crime Center, IC3, which is it's a complaint center that is maintained by the FBI, and it tracks crypto-related frauds and complaints. So this is publicly available information. The link is there. But for last year, over $4.57 billion in losses nationwide from internet-related crime. That includes cryptocurrencies. 2.9 of that is crypto. And Ohioans lost roughly $69 million with $58 million in crypto. And I'm sorry, did I say million or billion for that top? It's billion with a B. So there are a lot of losses, not only nationwide, but this is impacting people. This is money coming out of Ohio for investment advisors and dealers that are trying to comply, companies that are trying to comply. This is money that's coming out of legitimate investments that they could make with you. So it's a huge problem. How prevalent is it for what we at the division? And I will tell you, we see the tip of the iceberg because, they have to be a victim first, then they have to know it exists, and they have to reach out to us, then we have to investigate and we have to be able to take an action based on that investigation. So even given all of those parameters, this year to date, we've issued 14 administrative actions involving cryptocurrency. That's 30% of our total actions administratively. Those impacted over 1,200 Ohio residents. There was over $1 million in loss and over $3 million in unregistered accounts. And what I mean by that is that those are the NASA settlements where the violation was unregistered, but there was no allegation that the money was not there. Had 243 new complaints this year, and of those, 27% of them involved cryptocurrency. Okay, our top scams. Number one, financial grooming. which loosely translates. I'm gonna have a video about that later. This is the number one scam that we're seeing. I gave you the stats from 2024, but if you look at the last 60 days, it's much higher with that on what we're seeing on intake. Unlicensed activity, unregistered products, those can go hand in hand. Prom notes are still big and investment contracts. A lot of, if we're dealing with domestic fraud, a lot of it is prom note based, promissory note based. And then real estate investments we have a lot of complaints involving real estate investments, so that's on the rise. Okay, so this is a video about, this is not in Ohio, I will say, but it gives some background about the pig butchering, and it's called financial grooming now. But it gives you some background about how far the tentacles of these types of criminal activity lie.
As soon as I found out that it was a suicide, I was 100% sure that it was the scam. It crushed me. It took the life out of him.
It has only been a couple months since Matt and Adrian suddenly lost their father.
Our father was the grand optimist. And they extinguished that for him.
I meet them at Adrian's home in Northern Virginia, where their father's ashes have yet to be buried. Dennis Jones was an avid photographer, guitarist, and loving grandfather. But last summer, Dennis started withdrawing from the family, instead talking daily to a woman he met on Facebook.
The profile's name here is Jesse Shue. Do you think this person exists?
Yeah.
Over time, Jesse convinced Dennis to invest in cryptocurrency. He pumped more and more money in until it suddenly disappeared. Text messages show Dennis was desperate, and yet his children say he still trusted his friend named Jesse.
I do believe the person that he believed was behind that profile.
Corinna, who works in biotech in Northern California, was also the victim of an online cryptocurrency scam.
Were you and what?
I was. Yeah, I really felt like I trusted this person.
She says she first met her scammer on the dating app Bumble.
How much money?
In the end, I ultimately lost $150,000. I mean, I went into a depression. I was depressed. Ashamed, embarrassed that I had done all this without sharing it with anybody.
I've been a prosecutor for over 25 years. I spent 9 years in sexual assault, and I've never seen the absolute decimation of people that I've seen as a result of pig butchering.
Erin West is a deputy district attorney in Northern California, specializing in online crypto scams she calls pig butchering.
We've got over $5 billion in losses
In 2023.
in 2023, and that's up 38% from last year. And when crime is growing at 38%, that's something you better keep your eyes on.
Using fake social media profiles, scammers spend months gaining the confidence of their victims before convincing them to invest in cryptocurrency through fake websites. Those platforms claim huge profits until the money suddenly disappears into the pockets of criminal gangs, mostly based out of Southeast Asia. A 2023 CNN investigation revealed many scammers are actually themselves victims of human trafficking, like this Indian man named Rakesh. Imprisoned in this armed compound in Myanmar, he was forced to work pretending to be a Russian woman targeting Americans online.
Like they're providing for us. I got a Russian girl, with using a Russian girl fake profile, I need to scam the people.
Investigators warn of a mass transfer of wealth, stealing billions of dollars from ordinary Americans, and this year, they predict it will only get worse.
Okay, so I will tell you, if you haven't gotten a phishing attempt, if you haven't gotten a wrong number text or an email, then you're not checking your texts and your emails, or you have a fantastic blocker, and I'd like to see, because I get them daily, you know, I delete and block, but they're constant and consistent, and it's not something happening in New York or somewhere that's not here. It's happening here in Ohio, and people are losing their life savings. So, reach out to the people that you care about, reach out to the elderly. If you have people that are lonely or in assisted living, reach out to make sure that and we try to do this from a division perspective, make sure that they understand these scams. We have brochures that we can provide. If you want to provide them to your clients, we can give those to you for free. Just reach out to the division. We're here to help. So these normally start with like I said, a wrong number text. It's normally sometimes a picture. And then it quickly moves to an application for which we cannot issue process to get copies of the communication. So that's why they're moving to Telegram, WhatsApp, WeChat, because if the victim is not preserving that on their phone with screenshots or however, then we as law enforcement can't get access to it. So that's why they do it. And they're very good at it. What do we have? What are we doing as a division to help stop and prosecute this type of activity? So we have resources. So I will say a very big thank you to Andrea. She has been at the forefront of approving resources, of identifying resources. We are going to be posting for a position, a fintech position, where we will have somebody that can do these types of things, that's knowledgeable, so that we can be more proactive instead of reactive when it comes to stopping people from being victimized in these scams. We have Cellbrite Digital Forensics, so we use these in these cases. We may have an elderly victim who did preserve screenshots, or does have the ability to get communications on their phone. We have the ability to go out with our mobile unit and get a forensic image of their cell phone, so that we have all of those communications as part of the investigation, which are very important because they help us form the basis of that it's a security, that the person was providing investment advice, all of the things that we need to initiate action. We also have multiple licenses to chain analysis. We have our supervising investigator is certified in Ethereum and chain analysis and Reactor and Ethereum. So, and we have other investigators that are getting licensed and certified to be able to utilize these tools. So, what can we do? So this is a life cycle of case. This is an actual case, and this was an order that we issued this year. And, you know, a lot of, I would say most of these actors are overseas. So we don't have the ability to arrest them from the state of Ohio, but what we do have the ability to do is collaborate. Which we do. We collaborate with the FBI, with the CFTC, Aaron West, the prosecutor from Santa Clara. We're in groups with her, with our Canadian regulators. We are doing everything we can to leverage the resources we have to stop the flow of the money through these scams. But the other thing we have, which is what I talked about at the beginning, is the ability to provide some recovery through the Ohio Investor Recovery Fund. So while I would very much like to put these people behind bars, what I would also like to see is for money to go back to these investors who have lost, in some cases, their life savings. So let's go through the life cycle. This is an actual case. We received a complaint in March of last year. An elderly gentleman lost $225,000, which was a significant part of his life savings. It initiated with a wrong number text from a Caitlin Guo. Probably not his real name, but it was a romance scam. And this gentleman thought that he was in love and could trust this person, and it quickly moved to, can you invest? You can invest with me. I'm a good investor and I'll get you returns through this website, FastlyX. What we do on the investigation side is we preserve the website because it's a bit like whack-a-mole. When we know that there's a fraudulent website out there, they go up and down. As soon as the regulators find them, they shut them off, but they'll start under another .ic or .co or .syx, sometimes with the same name. Sometimes they'll put numbers after them. So they're clearly related. But so we preserve the website. In this case, we use Chainalysis to track the cryptocurrency transactions, but we did not find an identifiable individual targets through KYC information. So I'll break down what that is. So the useful part of Chainalysis from our perspective is it tells us where the crypto transactions move through what wallets, but it also tells us when that money comes out or flows through a servable platform. So when we see transactions that go through Coinbase or other platforms, we can issue a subpoena to them and say, give me all the information you have about this particular account. Also, if you have any KYC information. We have, from some of our sources, we get copies of driver's licenses with addresses in other countries. And so it does help us to initiate administrative action. The other thing that's helpful that's happened recently is a change on the administrative law side. And that is how we serve defendants. So it used to be that we had to serve them via certified mail to the last name address. If that wasn't effective, then we could publish. But if you're dealing with somebody in another country where we can't effectuate service through certified mail, we can't publish because there are certain requirements about how you publish that. We were left with the inability to take action, which meant that no recovery, right? Because recovery is dependent upon our ability to take action. The legislature changed 119.05 is the new statutory change that allows us to serve by email. And this is incredibly helpful for us because when you're setting up a domain registration for this website, you're going to get an email. You're going to give a contact. It may be a fake name and it may be a Gmail that you just set up, but it is a known contact for you or for the person that set up the website, and it is a servable email address. So we use our post. It's trackable. We get a message back when they access it and open it, and then service is deemed complete at that point. So we were able to serve via email in this particular case. Final division order was issued earlier this year, and then the victim in that particular case applied for recovery and received recovery at the maximum amount. So that's a success story in part. It would have been nice to get him all of it back, but it was a success story in part to get him a significant recovery on his loss. Okay, I've got 2 criminal cases. I think I can get through both of them. One of them has a video, so that'll be a little more fun. The first case is Robert Earl. This is a case that David Beamel, who helped organize a conference, he investigated and assisted with the prosecution. He does other things, fantastic conferences. Mr. Earl was not licensed. He lived in Westlake, Ohio, and he was selling investments in his company, Aquarius Fund 2. And Aquarius Fund 2, Aquarius 2 investment funds. The revenue generating portion of this was that he was going to be a day trader. So he touted himself as a successful day trader. He created this fund and he was going to generate returns on all the investors. He took about $347,000 from 12 investors. Along with that, so the money went into his personal trading account and trading losses, but he also liquidated some of that money into his own pocket. Referred the case for prosecution to Cuyahoga County, and Mr. Earl was, he pled guilty on February of this year to 22 felony counts, including securities fraud and theft. He was creating fake statements on just Word documents. They were very rudimentary, but they lulled people into believing that the money was actually there. And ordered to spend 2 years in prison and ordered to pay restitution. The reason that restitution figure is less than the amount that was invested is because there was an investor that was paid out prior to conviction. Very 1980s. I think we have time. The next case is a Warren County case, and this video will give you a great overview of that matter.
Well, WT, a former Warren County businessman, is facing serious charges. He's accused of stealing more than $1 million from a client for personal expenses. WLWT News 5's Rachel Shine joins us live from Lebanon with details. Rachel.
Well, Chris, Patrick Thayer was indicted today by the Warren County prosecutor. Thayer is accused of stealing more than $1.3 million from one of his clients and using her name to get away with it. A Lebanon businessman faces a list of charges after a Warren County grand jury indicted him for stealing money from a client. The prosecutor's office says in 2013, Patrick Thayer opened up a bank account with the victim's name without her knowing. He allegedly began selling securities using her information and transferred proceeds to that new bank account. Prosecutors say he used the money for a down payment on a home, paid off car loans, and purchased a tiny house in Colorado for a family member.
They're fairly serious. It's theft, with over $1 million at issue.
The former securities salesperson and investment advisor is charged with 2 counts of securities fraud, 1 count of aggravated theft, 1 count of telecommunications fraud, and 1 count of identity fraud.
There's a substantial sentencing potentially at issue.
Attorney David Newman is now representing the victim, but his firm is keeping an eye on Thayer after he says Thayer was barred by the Financial Industry Regulatory Authority.
It sounds like the victim had known the advisor for at least 10 years, and to keep that ruse going for at least a decade, really, really hurts on a personal level because it's somebody that you've trusted for such a long time.
The prosecutor's office says the alleged fraud was brought to the victim's attention in 2022 when the IRS reached out about Thayer's bank account with her name on it. It's a lesson to pay attention to your bank and ask for help if you're concerned.
Have a son or a daughter or a trusted person look at the statements too and say, hey, does this look out of the ordinary?
Thayer is scheduled to be arraigned on June 30th at the Warren County Common Pleas Court. We're live tonight in Lebanon. Rachel Mersheimer, WLWT News 5.
All right, Rachel, thank you. This indictment was the result of an investigation by the Ohio Department of Commerce, Division of Securities, and the Warren County Prosecutor's Office.
I will say this was Chris Ballard's investigation case. He does more than just keep time. He investigates cases, so he did a very nice job in investigating that case. Mr. Thayer was a licensee, unfortunately, at the time that he conducted these activities with 2 different firms, and the firm LPL, they're listed here, but they did step up and provide repayment to the client for the time period that this investor was, for the time period that Thayer was licensed with them. So he had a tax preparation business. He set up a bank account with Ally Bank. It's an online account. Username is very blatant, but from an investigative standpoint, he liquidated money from her securities accounts and flowed everything through this fake bank account. So we looked to make sure that there wasn't anything beyond this. But it's, from an accounting standpoint, not a great way to commit a crime because it's all traceable to that account. But anyway, he was convicted. He actually pled guilty, sentenced to 15 years in prison and ordered to pay $1 million in restitution. This is on appeal. I will mention briefly. This is on appeal, or I'm sorry, it was on appeal. It was appealed. And one of the bases for appeal was that the securities fraud count and the theft count should merge. They were allied offenses of similar import, and that they should have merged for purposes of sentencing, which they did not. The court rejected that argument and said that something along the lines of securities violations are crimes of trust, and he used not only his license but that fiduciary relationship And so that made it different than just a straight theft, and those counts did not merge for purposes of sending. All right, just a shout out to the website, we have a few minutes left. These are the main contacts at the enforcement section. We do have important contacts at or we have a list of all of the enforcement section contacts online. You can access that through our website.